Sovereignty. For many people, this is a scary concept. It raises all sorts of fears about a separate Indigenous state. Hello, welcome to the program. Australia is going through a debate right now about holding a referendum to recognise Aborigines and Torres Strait Islanders in the Constitution. But there is another argument that even that does not go far enough. Some Indigenous people claim they have never ceded sovereignty and that European settlement did not extinguish their rights. Now, this is not a new concept. It exists to varying degrees in other countries with Indigenous populations. So why not here? And what would sovereignty mean? Well, joining me now is Michael Anderson, the founder of the National Unity Government. Nice to have you here, Michael.
It's nice to be here.
Also joining us, Nicole Watson, a lawyer from University of Technology, Sydney. Nice
Hello.
to have you here as well. Michael, let's get some groundwork done here. Sovereignty. What would it mean very quickly?
Well, I think it re-establishes Aboriginal people's position within their own country, and it gives us a little bit more surety and certainty in terms of our arguments, in terms of the rights that we're continually arguing. Right now, we're behind the eight ball because we're arguing from someone else's interest, and it's not our interest. And I think what we need to do is set the record straight, and so that we can talk and take a natural pathway.
Should it be something that mainstream Australian, non-Indigenous Australians should be afraid of?
Well, I don't think they should be afraid of anything. It's a discussion that we need to have. It's like, rewriting Australia's history and telling, Australia's black history, and start talking about this. We need to bring this out in the open and have conversations. I don't think it should be, anybody should feel threatened or scared by open discussion, and that's one of the things that we lack in this country.
Nicole, there are real legal implications if you get down to talking about this. We know that there is a debate at the moment to recognise Indigenous people constitutionally within Australia, but this is very different. In many ways, this could be seen as antagonistic to the Constitution, couldn't it?
I don't think it should be seen as antagonistic at all. I guess we should establish at the beginning, though, what sovereignty is, and we should concede that there has been a diversity of opinion over the years as to what this term actually means. For some, it means the ability of a state to govern exclusively without interference from other states. But in a lot of advocacy for our people, it has meant the recognition, the realisation, I should say, of self-determination. And I would actually stick with the latter.
So you're not talking about the recognition of a state per se, but the recognition of Indigenous people within the Australian polity.
That's how I would see it. I would see it as a tool for us to achieve self-determination. I would also see the recognition of sovereignty as a step towards a treaty, which I believe is inevitable. For the last 2 centuries, we actually haven't had any kind of document that guides how we're going to coexist with non-Indigenous peoples. I think that a treaty would provide a path to that.
Is there a fundamental legal problem here? If you look at the Mabo decision, and the concern there is that they don't want to impose something that fractures the legal system of Australia, that challenges the very legal process in Australia. Wouldn't something like sovereignty do that? Wouldn't it be a fracture of the Australian legal system, something that operates outside of Australian structures?
Not necessarily. Look, the issue was last considered by the High Court in members of the Yorta Yorta Aboriginal community and Victoria, where the majority said that once the British acquired sovereignty, there was no parallel lawmaking system, which I think is illogical because Aboriginal rights are still recognised in native title that were created by this parallel lawmaking system. But when a lot of us talk about sovereignty in our advocacy, what we're actually talking about is self-determination. It's the vesting of more decision-making power at a local level. And it has been recognised, from Rickardick more recently to Little Children Are Sacred, that it is absolutely crucial for our people to be able to design policies and programs that affect us.
Michael, haven't we seen this to varying degrees before? I mean, you talk about ATSIC, that was set up to give people some autonomy and the ability to at least administer for Indigenous people themselves, if not exactly make laws. But are you talking about something that is different to that, more than self-determination, the full recognition of an Indigenous state?
Yeah, we're working from that as the basis for argument, because we haven't ceded sovereignty. And if you look at international law and all Blackstone's rulings and commentaries on English law and and how you acquire territory and how you acquire people's sovereignty. Australia does not fit into any of those categories. War was never declared on us, and we were never defeated. We never ever ceded our sovereignty at any time during colonial history or modern history.
The issue there, though, is that there was no recognition of sovereignty to cede in the first place because of terra nullius, isn't it?
Well, no, quite. Well, I'm glad you sort of talk about terra nullius, because if you go back to the Jack Cungo Murrell 1837 case, this is where it first came up, because in that case, the full court of the New South Wales Supreme Court at that time concluded that Aboriginal people did not have the capacities and civility to be able to form a government or have laws of their own that could be seen to equate to that of English lawmaking, and so as a consequence, they felt that because of the the fact that our people were uncivilized according to European law, and based on that we didn't have those capacities to be sovereign in our own right. Now, that sort of racist concepts in law cannot stand.
And we know that there has been a process here. If you look at the Mabo decision, if you look at native title arising from that, are we looking at a process? Can you draw a line here, Nicole, and say, look, there have been changes in law, there have been changes in legislation, and this is another step along the way?
I think that certainly the Mabo decision was a positive step. We did get rid of the racist application of terra nullius. However, Australia remained a settled place, and the High Court is yet to acknowledge that our sovereignty continues to exist. And as we know, the vast majority of Indigenous people have gained no benefit from native title legislation whatsoever.
But can I just say this though, on those points though, one of the things that Mabo's done, and this is what a lot of people have failed to look at, is that all those previous racist dictators from courts previous have now been overturned by that Mabo. Mabo really created a totally new agenda.
And a defining moment in Australia, and as you say, perhaps a platform that could lead to greater discussion. I'm going to bring someone else in now whose family has been linked for generations to the struggle for Indigenous rights. Diana Murray is the granddaughter of Sir Doug Nicholls, former Governor of South Australia. He introduced Diana to Indigenous politics, and she was involved in the 1967 referendum as well. Diana, welcome. Nice to have you here. If you look at your grandfather's work, if you look at 1967 and what that referendum meant, where are we now on the timeline of moving towards recognition of the separate status and rights of Indigenous people in Australia?
Well, what I really want to say here, where actually my focus is, and that's on the treaty and sovereignty. And I'd also like to acknowledge there with Michael Anderson, I was part of that land rights and the embassy also in the 70s as well, with people like Tika Dixon, Paul Coe and his sister, Gary Foley here from Victoria. Now, as I was saying before, my focus is really on the treaty.
And how important, Diana, is it to have a treaty, and what would that treaty mean?
Right. 67 referendum, that was good, but there were sections that were excluded in that referendum. Some were included, some were excluded. And so here we are now in the 21st century, and a treaty is what we need. Because you cannot pull a constitution, a referendum together without a treaty, a Bill
Diana,
of Rights.
Can I just bring in a question here? Because the argument has been, when the treaty question has been raised, you've heard this from successive politicians in Australia, that a country can't have a treaty with itself. I think the difficulty for a lot of people is getting to the point where they can recognise that there are independent and separate people within Australia with a separate legal definition, separate histories, who need to be able to come together. How would a treaty work in effect?
Well, the Aboriginal people have always been here. It is not a matter of us fitting in. We have always been here. We are the first Australians, and we need to all unite as one and have a treaty, because that would pull in that constitution and a referendum regarding a Bill of Rights, and also a treaty is the going back to the British Empire of the Queen under the Federation, the Commonwealth, that a treaty would be a legal foundation of the law. That's what's important.
Okay, well, we have a lawyer here, Nicole Watson, who's with us right now. When we talk about a treaty, what it means in fact, and the possibility of being able to achieve such an outcome in Australia, is it just a pipe dream? How would it work?
Look, I should say that there's been a fair bit of the intellectual heavy lifting already done. In the 1980s and the 1990s, there was a lot of work done by bodies like ATSIC. They had their ATSIC treaty think tank that produced a lot of work on how we should approach the question of a treaty. And I think that it would be a very positive thing because it would dictate the terms of coexistence.
But it's difficult. How do you codify something when there are different claims and different groups throughout Australia and there wasn't one Indigenous group at one particular time that you could deal with? It would have different effects in different parts of the nation, wouldn't it?
Well, one of the possibilities was having a national framework. And I think it was Pat Dodson who actually came up with the idea of a treaty commission. Now, you would have a national framework that would lay down the standards, but you would have treaties negotiated on a regional level.
How does this work internationally, Michael? Because I know you've looked at this case overseas.
Can I first just deal with what Nicole has just said? Malcolm Fraser was actually negotiating, the Liberal government with John Howard, the Treasurer. They were actually negotiating a treaty with the National Aboriginal Conference from 1979 to 1985.
And we heard Bob Hawke talk about a potential for a treaty or a compact.
But Bob Hawke was the one that shut down the whole process, quite frankly. He and a bloke called Klein Holding. And we got to the point where we were having meetings. When I say we, I was the director of the research for the treaty for the NAC. And we were actually negotiating with the Cabinet, the NAC Executive and the Cabinet of Australia, the Parliamentary Cabinet, with Malcolm Fraser at the head as Prime Minister. And we were looking at this, and in fact, the Parliament actually commissioned a Senate Standing Committee on Constitutional and Legal Affairs to look at how you would enter into a treaty or a compact or some other arrangement with Aboriginal people. And of course, in 1983, they looked at this whole concept of Aboriginal sovereignty, continuing Aboriginal sovereignty. That's in a report called 200 Years Later.
So there has been a process that's been opened and shut down at various times.
But that was going for 3 years.
I just want to know, for people who are afraid of this, and some Indigenous people too, who go, what are you talking about here? Are you saying we're not going to be Australians anymore? What does this mean? How does this work elsewhere in the world? We know that there is dependent nation status in some parts of North America. The Hawaiian experience is different again. From what you've seen, how does it work? In
North America, the Americans they're still arguing that the treaties that they entered into with the British, who came into America at the time prior to the American Revolution of Independence, they were arguing, and they continue to argue, that their treaties were international treaties between them and Britain in terms of land. If you look at them now, they're basically classified as land use agreement, Indigenous land use agreements. That's what you could equate them to. And they argue that those treaties are not domestic treaties. And of course, this is our position here in Australia as well when we take the North American experience. The question we have to ask, and Paul Coe raised this question at a summit meeting about 3 years ago now we had in Canberra. And one of the things that Paul stood up and said, look, he said, we got to ask ourselves, do we classify ourselves under international law and go for international sovereign status as a nation state or as a series of nation states, as you rightfully say? We are there's a multiplicity of tribes and nations around this country. And he said, if that's the case, then we need to look at how we unite or whether we go as individual nation states to the international corporate bodies, like the UN or whatever the case may be. And then, or do we look at ourselves as dependent nation states, which is what you started off with in the beginning, where we then come under and recognise the sovereign integrity of the nation state.
Which I think is what you might be talking about, Nicole, that there is more self-determination, but not separatism.
Not separate.
In North America, it has been proven that exercising a degree of sovereignty can actually lead to beneficial outcomes such as economic development. And if you look at the Harvard Native American the Harvard Project on Native American Indian economic development, you can see that groups who have the power to design their governing institutions so that there is a cultural match actually experience economic development. There are also greater health outcomes as well. So I think that some degree of recognition of sovereignty can actually produce great outcomes for our people. And it also produces greater outcomes for non-Indigenous Australians as well, because it would give a sense of legitimacy to the way that this country came about.
That's a really good point, and I'll bring Diana Murray back in with us before we wrap this topic up. Diana, the question of our status in Australia, Indigenous people status in Australia, is your argument that Indigenous people should be separate from the rest of Australia, should be part of Australia in a dependent sovereignty model? To what extent would the upcoming referendum that's being talked about deal with those questions by acknowledging people in the Constitution?
My opinion is that we're all Australians here now, since colonisation, and we are all very much, as well as us being first Australians, of multiculturalism. But as I said before, a treaty is vital, a sovereignty, because you have to look at the past injustices, and that has been, genocide.
And just sort of wrapping this up now.
That needs to be fixed.
Thank you, Diana, and we'll leave you there. Diana Murray has been joining us in Melbourne with this discussion of sovereignty and what exactly it would mean. Michael, is it just about injustice, as Diana has said there, or is it much bigger than that?
It's much broader than that. There's a lot of issues at stake here, and I think what we need to do is have a look at some of these South African experience and the way in which they've settled their disputes in South Africa, and I think we can learn a lot from the way in which they progressed into nationhood and into a united sort of nation, I guess, of in South Africa, bringing the people together, amidst all of those, atrocities that were perpetrated against the people under apartheid. And I think what we need to do here is we can do something similar, and we need to do something similar because there's a lot of Aboriginal people out there still hurting.
So a truth and reconciliation commission
we need something like that, and we need also to put up the monuments to the people who were slaughtered out there, because you go to Germany. If the Germans can be forced to face up to and teach the atrocities in their school about what Hitler did with these people and against the Jewish population, then surely Australia is big enough and mature enough to do similar. And I think that's absolutely important. And if I could just conclude,
just quickly, Michael, I'm almost out of time.
Yeah. Sure.
So thank you so much for coming in and sharing your views with us. Of course, this is a vast topic, and I know we're going to revisit this at some point, the question of sovereignty, what it means for Australia. Hopefully we've cleared up a little bit of the potential fear here and what may be involved. But Michael Anderson, thank you for coming in. Nicole Watson as well, thank you for sharing your views with us.
Thank you.